Hello, everybody. It's Dave Neal, stand-up comic and host of Bachelor Nation News, recording live from Aquidneck Island in Rhode Island, New England. We've got all of your updates here with a little coastal breeze. That's right. Your boy's doing just fine with that salt water in the air. And you know who's not doing fine is Laura Owens. I'm going to discuss the judge who denied the request for a new trial. My name is mentioned, I'm guessing, about 24 times. It's absolutely banana land. I could not believe it. When I read this motion, I was actually getting ready for my flight. You know, it's my infant son's first time traveling. He did great. He landed the plane. He's an expert. They didn't give him wings, though. We need to make sure. JetBlue did not give my son wings, and damn if I'm denied wings as the son of a power recapper. So why am I in the story? That's interesting. And I guess I'll give you the overall breakdown. I recorded live, 6 hours or so here. I wish I had a higher quality recording. This is because I was recording from a parking lot. It was no less than 125 degrees on the parking lot. If you were there, you know. And the generator went out in the van that we had rented, so we were using the other air conditioning. It was a whole mess. Either way, I say all that to say the internet was no bueno, but the audio was okay. And in this conversation, in the spill out after the hearing, there was people talking about the fact that the judge's father was there, and I joke around and say, ho, let's not have a mistrial. Well, of course, in taking everything with the letter of the law, Laura Owens' attorney, the Honorable, say that with a grain of salt, David Gingras, old Jingy, decided to request a new judge because he didn't like the results that he got. And not only did he not like the results that he got, he has now gone quiet. His tweets are protected. Account temporarily set to private due to excess justice for Clayton's silliness. And of course, what he really means by that is he doesn't like people rubbing truth and victory in his face because he's tried to piss on everybody's legs for the last 3 months and tell people it's raining. We know what rain looks like, and this ain't it. So I've got this story for you. Right after this, make sure you are subscribed because we are throwing fastballs down the middle. I've got prosecutor discusses Laura Owens' case. What's that? An actual prosecutor that we pay for with our tax dollars, at least you do in Maricopa County, is investigating Laura Owens for potential perjury and maybe other charges. Well, I'm going to share it with you what the prosecutor had to say. This is no joke anymore, folks. Now, it probably never was, but when my family is going to ask me, hey, what's up with that lady who was trying to sue you? When I tell them, oh, she's being investigated by county prosecutors. Oh, really? They should make a documentary out of that. They are. You know what I mean? It's like, we got a lot of catching up to do. When I was home last time, we had a lawyer friend hand me a little book of objections. I guess lawyers pass around these things as, you know, why share, bouquets of roses when you can share a book of objections? And anyhow, it's, I've had family say, hey, Dave, what is that? And I go, look, I can give you the quick version, but that's still 45 minutes. So let me know if you want to know. And if you don't, just let's not even get into it. All right. And by the way, hopefully they've subscribed to the channel. All right. So we'll discuss that. But first, let's get into it. Here is the response. So you ever been to a Chipotle and you get in a fight with the guy who works the counter and you say, I want to talk to your manager? Well, that's what Gingras said. I want to talk to the manager being the judge's boss, the judge of the judge. In the matter of Laura Owens and Clayton Echard, minute entry. So this is their response to Gingras throwing a Hail Mary. Of course, Hail Mary is a Catholic term, as we know now that I'm in a heavily Catholicized region. Is that a real term? It should be here. My family subscribes to the Providence, Rhode Island Virgin of the Catholic, which, by the way, is a real page turner if you're looking for your up-to-date niche Roman Catholic news in the smallest state in the country. But I digress. Please, if God and my Catholic brethren could like this video and follow us, we'd appreciate that. Please be a disciple of the channel. We appreciate that. and also with you. Okay, so here's what they had to say after this Hail Mary attempt. This court has considered petitioner Laura Owens' notice of change of judge for cause, memorandum and affidavit of support. Hereafter, the Rule 6.1 motion in the separate affidavit of David Jingy in support of petitioner's notice of change of judge for cause. Hereafter, the affidavit. Both filed July 8th, 2024, in respondent Clayton Echard's response to notice of change of judge for cause. So, will they get a new judge? Now, we already buried the lead here, if that's a term we're allowed to use. I've been told I'm using it wrong. Who cares? You know what I mean? Who cares? So anyway, the Rule 6.1 motion was filed after Judge Mata's June 17th ruling, filed June 18th, and days before petitioner filed various post-trial motions. Judge Mata prematurely ruled on the post-trial motions. That ruling was withdrawn. Minute entry ruling July 23rd. Now that this court has ruled on the Rule 6.1 motion for change of judge, Judge Mata may rule on the pending motions. So yeah, any motions, I guess, after Jingy asked for a new judge, they held off on. So what happened was, and I could be wrong, but leave a comment if I've got this right. What happened was Jingy filed this motion to get the judge changed. At the same time, before that motion made its way to the judge, because that goes to the presiding judge, the Judge Mata has ruled on all these things. Then they had to say, whoa. None of these rulings matter until we talk to the manager. We spoke to the manager. Now Judge Mata can go back to making her rulings because, spoiler, it was all denied. Everything's denied. Petitioner's Rule 6.1 motion seeks to disqualify for cause the assigned family court judge, Judge Julie Mata, a beautiful judge, on the basis of bias and prejudice within the meaning of ARS 12409. Specifically, petitioner alleges that, and that's petitioner is Laura Owens, alleges that Judge Mata purportedly did the following: performed an independent investigation into the facts of the case, and in so doing, considered and relied upon information posted on the internet about the case. And two, engaged in ex parte communications regarding the case with her father, Harry Howe, who appeared at the trial as a spectator. As a threshold matter, this court apologizes to the parties for the delay in issuing this ruling. The court had technical difficulties opening the compilation CD included with the affidavit. When opened with Windows Media Player, the files entitled produced an error message. We can't open Judge Mata's dad compilation. It uses unsupported encoded settings. With technical assistance, the court finally was able to open and review the compilation CD using VLC Media Player. I'm telling you what, VLC Media Player, I could have told them if the Honorable Judge Mata asked me, I could have helped them out. I'm sure Bruce from Oregon also could have helped them out. VLC Media Player always works when nothing else will work. I don't know why they don't just use that as the base one, but if you're VLC Media Player, you are going to use this case study to let people know why they should be downloading your software. And also, did anyone else get a real nostalgic 1998 high when they talked about burning CDs? I was going to ask if they were going to have the Venga Boys for a second, you know. I like to party, ha ha ha. You know what's that song called? Come on, Baba, let's go. Come on, Bobby, let's go party. Hoo-hoo-hoo-hoo-hoo. Okay, you get the point. Burnings. We used to pay a guy $10 to burn CDs for us. He was running the CD burning black market. This was before Pirate Bay existed. This was, I believe, the LimeWire days. You probably don't know what I'm talking about. Someday I'll sit down my son when he's old enough to understand. I'll say, son, and he'll say, Dad, please, can we not do this? And I'll say, son, I want to talk to you about a thing called LimeWire and how we tried to download Britney Spears music, but we just got porn. That's how you. Okay, let's move it on. We are digressing today. All right, so they got the CD opened. Gosh, the year of 2024. I get it. When they say don't trust government with innovation, I now understand. This is why. Reboot it, blow on it. If you just blow on it and plug it back in, it usually works. Unless you're Clayton, don't blow on that. You might have a kid or two. or not. Respondent contends that the Rule 6.1 motion is time barred under ARS blah, 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 on the basis that it was filed after final trial and final judgments under Rule 78. See response at 4. This court finds that the analysis as to timeliness is more nuanced than respondent suggests. A Rule 6.1 motion for change of judge for cause must be filed within 20 days of discovering that grounds exist for a change of judge. This court must at least consider the factual allegations to determine whether they are time barred. The Rule 6.1 motion and affidavit alleges as follows. Judge Mata held an evidentiary hearing on June 10th. Okay, so we got all that information. Oh, here we are. I'm in it. Judge Mata's father, Harry Howe, attended the June 10th hearing as a spectator and spoke to other people in attendance. Individuals Dave Neal and Megan Fox, among others, live streamed and posted on social media various interviews with people who spoke to Mr. Howe at the hearing, accompanying compilation CD. So rather than accompany their CD, let's just play the clip they're talking about. Here we are after the hearing in our best pressed linen.
Yeah, Judge Mata's dad was in the court with us.
Judge Mata's dad
was in the court with us.
No way.
In the side room where we were. Judge Mata's dad was sitting there.
She did fantastic.
Yeah. I said, Harry, that's really nice. You want to be here?
Notice when they mentioned the father, I said she did fantastic, bringing the conversation back to the judge. Now we have a noble audience member of the Justice for Clayton community, one in which Gingras calls a cult. Do they look cultish to you?
Support your daughter. He said, oh, no, I've been hearing about this. I'm here for the circus.
Oh, my gosh. Hold on. We don't need a mistrial.
Yeah.
Well, I mean, we could get him some scones.
Yeah, scones. If there's any food, if anyone wants any food or drinks, and then I masterfully let people know about our wonderful caterer who brought food, drinks. There were scones, cold brew coffee. I mean, honestly, they had everything but a porta potty. If I had a porta potty, I could have drank more scones and coffee, or ate more scones. I'll blend them up. Could you imagine? Wait, what type of coffee is this? It's scone-flavored coffee. It's blueberry scone-flavored coffee. Okay, let us continue. So that's where I'm involved. The fact that as a reporter of comedic value, I'm shucking it up, as it were, with the audience here, the lay audience that we are. So anyway, they continue after getting my name in the court documents. So that was the first time. Let's see how many more times. Rule 6.1 motion alleges that these two actions separately violated rules initiating, permitting, or considering ex parte communications outside the presence of the parties or their lawyers. It is not for this court to determine whether Judge Mata has violated the Arizona rules of judicial conduct. Moreover, the Rule 6.1 motion makes vague allegations of violations of petitioner's right to due process of law under both the U.S. and Arizona constitutions. I don't know, guys. Do you think vague allegations are going to hold up in court? I don't know. Vague allegation. That sounds like a fun ska band that I would have burnt a CD to. Hey, did you get me that CD? I need Venga Boys and Vague Allegation. And do you have Offspring? I'm going to need Offspring. I asked for Ratatouille. I asked for ink done. I asked for a 16. They drew a 31. Friends say I'm trying too hard. I'm probably messing up all the lyrics, and I'm not quite hip. Anyway, let's go. Sometimes I forget people are actually watching this. And then I'm going to get a message. Dave, can you not sing? Can you not rap? Let me live. All right. If you don't, I'll make. You know what? I'll make the Catholic Diocese newspaper interesting over here, okay? We're going to go up in flames. Based on the foregoing, the court finds that the Rule 6.1 motion filed on July 8th was timely filed. In making this finding, the court acknowledges that within 20 days is Sunday, July 7th, given the circumstances of this case, including the fact that petitioner's counsel was on a previously disclosed vacation. The court finds that the filing of the motion on the next business day was timely. The affidavit also, I think that's the only win that he's received. The affidavit also details various facts and rulings that petitioner's counsel alleges constitute a summary of pretrial judicial bias, a summary of judicial misconduct, and bias at trial. The court finds that these events that petitioner contends constitute misconduct and bias occurred and were known to the petitioner more than 20 days before she filed her Rule 6.1 motion. The court will limit its evaluation of the Rule 6.1 motion solely to the two allegations identified in the second paragraph of this ruling. All right, let's get to the goods. Let's keep on rolling. Petitioner has requested that this court hold a hearing in order subpoenas ad testificandum for Judge Mata and Harry Howe. A proceeding judge reviewing a Rule 6.1 motion for a change of judge as a matter of right has discretion as to whether to hold an evidentiary hearing. The presiding judge may hold a hearing to determine the issues raised in the affidavit or may decide the issues based on any affidavits and memoranda filed by the parties. The court denies petitioner's request and will decide the Rule 6.1 motion on the affidavit and memoranda filed by the parties, as well as those items on the docket of which this court takes judicial notice. Analysis of cause for change of judge. A party seeking a change of judge for cause must establish grounds by affidavit. One of the grounds which may be alleged for change of judge is that the party filing the affidavit has cause to believe and does believe that on account of the bias, prejudice, or interest of the judge, he cannot obtain a fair and impartial trial. The sufficiency of any cause to believe must be determined by an objective standard, not by reference to the affiant's subjective belief. So then they go into case law. Allegations of independent investigation by Judge Mata. Laura Owens correctly points out that Judge Mata's July 17th ruling contained a factual error. The transcript from the June 10th hearing shows that Dr. Samantha Deans did not testify that Planned Parenthood is not open on Sundays. So this whole thing is because the judge realized that Laura was lying. So they're like, we need a new judge. The judge figured out Laura was lying. And of course, I understand they don't want the judge, I guess, doing extra research that wasn't presented there. But sometimes when someone lies, they don't get fact checked in real time. Like people weren't even on to Laura's lies because it's something she never said before, which was that she went to Planned Parenthood in Los Angeles on a Sunday. And then we found out later on they're closed on a Sunday in Los Angeles. We know that because Laura lied. She lied. Where's my lie button? I actually spent extra money here bringing my good content with myself here, just so, I don't normally travel with this content. Usually I've got, my other smaller mobile setup, but just for you guys, I brought this content here just to have this moment right here.
She lied.
To demonstrate bias, petitioner asked the court to infer that Judge Mata's erroneous findings constitute irrefutable evidence that she performed a secret, undisclosed investigation in the facts of this matter, and copy that finding from posts on social media. In support of this position, the affidavit includes snips of a comment on petitioner's counsel's website. Planned Parenthood isn't even open on Sunday in LA, and comment posted by anonymous Twitter user. It was a Sunday, and all LA Planned Parenthood locations are closed on a Sunday. All right, so Gingras is upset that she found out that Laura was lying. The court finds petitioner relies on more speculation and suspicion when alleging that Judge Mata engaged in a secret, undisclosed investigation and therefore is biased. The record evidence reflects conflicting testimony about the date, and time, blah, blah, blah. So let's just move it on. Dr. Deans testified that she had reviewed the altered ultrasound and available medical records to prepare a report. Dr. Deans expressed concern about the legitimacy of petitioner's medical records. Dr. Deans confirmed that Planned Parenthood's national guidelines require identification at the time of a visit to confirm the identity of a patient. The patient can't be seen anonymously. Dr. Deans' testimony did not address which days of the week the Planned Parenthood offices were opened. It would if your client had disclosed that they were going to say that they went to a new place. Based on the foregoing, the court. So if Laura told them ahead of time, no, I went to a Planned Parenthood in LA, then they would have been able to research that. But she just pulled new things out of her ass, and short of being a, savant who knows every Planned Parenthood location. Oh, yeah, no, I went to Planned Parenthood Albuquerque. Well, they don't open on Tuesday. What? How do you know that? Well, because I memorized all the Planned Parenthood locations just in the hope that one day while I'm on trial, someone pulling a new location and date and time out of their ass can be used against them. Petitioner alleges that Judge Mata's father, Harry, was present in the overflow room during the trial and spoke with several of respondents' supporters during and after the trial. Petitioner's counsel admits that the mere fact Judge Mata's father attended the trial, if true, is not the primary concern. For purposes of deciding the Rule 6.1 motion, the court accepts these allegations as true and finds that if they occurred, was not improper for Judge Mata's father to attend a public trial as a spectator and speak to other courtroom observers. All right, fine. So, even they admit, not a big problem. Petitioner asked the court to infer the various statements made by courtroom observers about Mr. Howe confirm that Judge Mata was biased or prejudiced against petitioner. Petitioner's counsel acknowledges that his personal view, based on the past several months, is that Clayton's followers are generally not honest or reliable. Nevertheless, can you imagine that? Saying Clayton's followers are not reliable. Wow. Nevertheless, petitioner's counsel asked this court to find that an edited compilation of these individuals' comments about Judge Mata's father are clear extrajudicial evidence showing that Judge Mata had a hostile feeling or spirit of ill will or undue friendship or favoritism towards one of the litigants. And again, so as much as as much as Gingras hates Trump, he's doing the Trump playbook. It's a political persecution. So Gingras is saying that his client's being persecuted, or saying that Clayton's being believed because they're all infatuated by celebrity. Yeah, Clayton's so famous. He's flipping Tom Hanks. Yeah. Old, oh yeah. Was he in Castaway? Is that? No, that's a guy that was, 5th runner-up or 9th runner-up on a reality show. Applying an objective standard not by reference to the affiant's subjective belief. Okay, they continue. Statements by Hava Darby. Petitioner alleges that Miss Darby, who speaks between 0 and 40 seconds in the compilation CD, also made statements which appear to imply that Judge Mata told her father that she intended to rule in favor of Clayton before the case was tried. The first video clip on the compilation CD depicts a virtual meeting among 9 participants with screen names, including one woman with the screen name Hava Derby. Miss Derby holds up her phone and makes the following statement. I ran into Judge Mata's dad in the parking lot afterwards, and I asked him, well, what do you think? And he was like, I got to show you something. What? So he whips out these papers in his hands, and I haven't been online really today, but did anybody I saw kind of briefly that it was denied this request for findings of fact and conclusions of law proposed findings? Male voice, that wasn't denied. That was not denied? Okay, so anyway, did anybody get a copy of this? He was saying, Julie told me this is just, you dad got to read this, and printed out a copy. Unintelligible. For purpose of deciding Rule 6 motion, this court accepts that the scenario recounted by Miss Derby might have occurred, though Miss Derby appears not to be clear as to exactly what she is talking about. All right, if Miss Derby is not clear to what she is talking about, how is the judge going to find in favor? I mean, this is just bizarre. Statements of Dave Neal and individuals speaking with him. All right, now we're getting interesting. Petitioner's counsels, and by the way, thank you for giving me some credit here. Petitioner's counsel's affidavit further alleges that an individual named Dave Neal made remarks to, and by the way, I understand legalese, an individual named Dave Neal. I'm gonna brush the dirt off my shoulder if you don't mind, because I got 99 problems, but Laura Owens ain't one of them, okay? I ain't just an individual. I am the tip of the spear of justice for Clayton, metaphorically, that has pierced through the facade of all these lies and struck through the heart of justice, okay? That's who I am, and that's what we have done. The second video clip of the compilation CD depicts a group of people standing under an awning. The bottom left corner of the screen says, Dave Neal, Rush Hour Podcast. Yes, we've done it. Thank you. We've made it.
I just took a DNA test.
We are here. The podcast is thriving, and we are mentioned in the court documents. Will we get a good Google search from this? Now they're going to claim Dave's doing this for all the wrong reasons. Who cares? What does it matter? In the foreground, there are 2 men talking, one in a red shirt and the other in a hat, identified in the affidavit as Dave Neal. While the 2 men are talking, a woman in a hat approaches and joins their conversation. A woman on left in a black shirt chimes in, and a second woman on the right in a black shirt follows up. Male in red shirt, Judge Mata's dad was, and by the way, how about some respect for reality, Steve? Male in a red shirt. This is blogging king, spoiler, king of Bachelor Nation. You address him with the respect he deserves, good sir. You might be a local lawyer in a niche part of Arizona. This is a international icon known as Steve Carbone, a.k.a. Reality Steve, a.k.a. Olive Garden master, whatever. You get the point. Let's keep going. So anyway, they literally just show me here. We could get him some scones, says male in the red shirt. Yes, scones. So we're talking about the scones. Everyone wants a scone right now. Big scone energy. Why did I bring up scones in the first place? I don't know. One day I was just talking about scones. I must have been eating keto. Whenever you eat keto, you start thinking about things you can't have. It's like when you get married and you just start looking at people that aren't your wife. You're like, that's how I think about scones. You get the point, respectfully. Again, for purposes of deciding the rule, this court accepts that certain facts recounted by these courtroom observers might have occurred. Mr. Howe might have informed an observer before the hearing that he heard about the case from Judge Mata. Mr. Howe might have told an observer he considered the hearing and additional goings-on to be a circus. And Mr. Howe might have been reviewing paperwork related to the case. When viewed by an objective standard, Mr. Howe's alleged statements and actions do not prove by a preponderance of the evidence that Judge Mata was biased or prejudiced, or that she told her family members how she intended to rule before the case was tried. This court also finds that certain statements made by the courtroom observers reflect nothing more than mere conjecture. Like Mr. Neal's statement that Mr. Howe was probably a judge. I feel like it runs in the family. The court further finds that the video reflects that Mr. Neal's remark, "We don't need a mistrial," after the speaker started walking away, was made in jest, as evidenced by his and the onlookers' laughter in his agreement with another bystander that they should get him a scone. Are you kidding me? Are you kidding me right now? This is hilarious. What a country we live in. What a country indeed, that the scones can be the reason that we get out of this thing. I mean, look, luckily, my 13 years of being a stand-up comedian can conjure up a laugh in the right moment, and that laugh resided well with the judge here, as they then decide, hey, Dave's just joshing you. He's just having fun. And you're allowed to do that in this country. And it sucks that it takes a judge to have to, acknowledge, oh yeah, he was saying, get me a scone. How funny is that? So the judge is literally watching this part right here. It's on the other side, but have a cold. Hold on, we don't need a mistrial.
Yeah.
Well, I mean, we could get him some scones.
Yeah, scones. If there's any food, if anyone wants any food or drink. All right, so anyway, we continue. What a day. What's the Patreon thinking? We're live on Patreon right now. Patreon.com/Dave Neal. Bruce said my scones comment saved the case. Therese said donuts aren't bougie enough. Yeah, that's true. Stephanie says male in suit needs to be properly credited. And Henrietta says, because breadsticks weren't morning available. Oh, that's right. We couldn't get breadsticks in the morning, so we switched to scones. How wild is this? The court concurs with petitioner's counsel. By the way, get him a scone. Should get him a scone be merchandise that we make? Justice for Clayton, get him a scone. The court concurs with petitioner's counsel's subjective belief that respondents' supporters gleefully celebrated Judge Mata's father's attendance at the hearing, and that the supporters' actions, and perhaps even Mr. Howe's alleged actions, can be perceived to have made a mockery of these proceedings. Let me tell you something. You know who made a mockery of these proceedings? Laura Owens made a mockery of these proceedings. Are you kidding me? The only reason I had to leave my beautiful family to head over to the hottest part of the world, literally 125 degrees, maybe 150. People will tell you we couldn't even get onto the roof of my van because it was so scorching hot. Our shoes were melting into the sunroof. So yes, I left my family to come report here, not to make a mockery, but to show how dumb this person is, respectfully, my opinion, for thinking they could get away with all of this. And by the way, our next video will discuss how they are not getting away. So yes, all the best reactions are here when it comes to finding out you're probably going to get arrested for perjury. There, she's going to enjoy. A jail cell is like an upgrade from the casita. She's going to have fine dining. The internet will be probably okay. She can watch some of our YouTube videos if she wants. Will they get her a scone? I don't know if they do scones in prison, but maybe she can, I don't know, maybe there's prison favors you can do for a scone. I don't really know how it works these days. The court concurs, so they move on. The court concurs with petitioner's counsel's subjective belief, so that they gleefully celebrate. Imagine not being able to celebrate in the parking lot. It is ordered denying petitioner's motion for change of judge for cause. It is further ordered denying respondent's request for leave to file a supplemental affidavit of attorney's fees and costs. It is further ordered denying respondent's request for this court to enter further orders pursuant to Rule 8.2. It is further ordered returning this matter to Judge Mata to rule on all pending post-trial motions. Oh, I wonder how Judge Mata is going to rule now that she's been accused of being biased. I'm sure this happens a lot with judges from lawyers who can't take a loss. Look, I can take a loss. We don't know. We don't always win cases. Learn how to take the loss. Either way, there is no loss in the Justice for Clayton community today because the judge denies Laura's request for a new judge, which means short of them appealing, and the question is, will they appeal? We'll have to see. Now, I did have, let's see here. I don't know if I'm going to be able to find this, but we did have her attorney commenting on the matter here, saying, oh, Clayton won again. yawn. It's really not important to share. Maybe I'll find it for the next video here. But either way, just an absolute wild time. This always happens when I'm traveling. You know, the big news happened when I was literally in Qatar, and now I'm literally on a tarmac last night going, can I cover this in time? I did give an update, and I will give another update on the Rush Hour podcast. If you want concise information, pop culture, entertainment news all in one place, go to Rush Hour Podcast and get that content in. I appreciate all the support. We'll be back with more right after this.